Okay, folks, we are now moving on to Chapter 23. This is the Law of Contracts, Community College of Rhode Island, Spring 2020. This is our final chapter, the end of the road. All right, Chapter 23 deals with warranties. I like to describe warranties as part of the contract that continues out in time beyond the main performance in the agreement. Now, warranties are assurances, are guarantees that goods will perform as intended and that they will not harm or cause injury. But the idea of a warranty is most readily analogized to what happens when you purchase a car. Not even an analogy, the reality. When you purchase a car, the basic performance takes place immediately. You're buying a $30,000 brand new car. You have to come up with $30,000 either by way of a loan or with money you had in the bank, bring a check to the dealer. They give you title and ownership of the car. However, along with the car come warranties. So the basic contract has been performed. You gave the money, they gave you the goods. However, the warranties say that for a period of time, and in some new cars it's 5 years, 60,000 miles, 100,000 miles, there are promises that if anything happens to the car, it doesn't work correctly, that the manufacturer and or through the dealer will make sure that the car gets repaired, that the car is kept running, that the car maintains its ability to do what it's supposed to do. So in effect, what has happened, all of the contract has been performed except for one little condition, which is a condition that says should the car break down during a certain period of time or before a certain number of miles have been incurred, that it remains the responsibility of the dealer and the manufacturer to see that the car is repaired. There are express warranties and there are implied warranties. Express warranties are very much of the nature of auto warranties that we just spoke about, where as part of the bargain for consideration, the buyer is looking for, the lessor is looking for certain promises that will be made that will guarantee the product will work and will be safe for them. Implied warranties here are warranties that are created by law. There are really no warranties by implication because of actions of the parties or words of the party. If they were words, they'd be expressed, but by actions of the parties or by course of dealing. But the UCC in particular sets out several warranties that are created by the law. They are there whether the parties want them to be there or not. Sometimes they can be modified or they can be waived by the parties, but the UCC makes it somewhat difficult for that to happen. So basically what happens is with implied warranties, on every transaction that is covered by the UCC, the warranties exist. They are there. Now, the first warranty that comes into play under the UCC is something called the warranty of title. And basically what that is saying is that the seller or the lessor are the owner of the property, they have good title of the property, and they have the right to give ownership or the lease for the term that's described in the contract to the buyer or the lessor. They're basically saying that no one will show up saying, oh, they didn't really own that, I want it, I have a court order to take it back, or they owed money on that and now you must pay me whatever they owed in order to keep it. They're basically saying that they're the owners of the property. There are no liens. A lien is a claim that a creditor has that would allow them to take possession of the goods if the creditor is not paid. There is a formal process under the UCC called a secured transaction to establish liens, and the liens are filed with the Secretary of State, with the County Register of Deeds, or the local Register of Deeds. So there are ways to check to see if these liens exist. But again, a seller, unless they admit or tell you of a lien, they are selling you the goods saying that there are no liens. They're also saying there is no infringement. Infringement would be when the good or the product somehow violates a patent, a copyright, or a trademark held by somebody who is not the seller or the lessor. If a claim is made in terms of infringement, the person against whom it's made, particularly if they're a merchant, not so much a consumer, but if it's a merchant receives a claim that, oh, the goods that you got from X that you're trying to sell are infringing on our copyright, the merchant must give notice to the person from whom they obtain the property, to give that person an attempt to defend their rights and to prove that the infringement is not valid. And only after they give them notice and give them the opportunity to sue do they acquire the rights to bring an action concerning the infringement. Express warranties are created by statements of fact. The UCC interpretation of this is very broad. Any affirmation of fact or promise made during negotiations, any description in an ad, a brochure, online, any sample or model shown to a buyer, all of these create express warranties in addition to whatever the parties actually write into their agreement. So when we're talking about warranties, the rule of integrated contracts does not necessarily apply for UCC goods. The UCC will go back and look at what claims were made during the process of negotiation or the process of trying to get the buyer to buy. The seller does not have to use the word warranty or guarantee. Any representation about the quality of the goods made as part of the basis of the bargain, that is, they are relied on by the buyer, are sufficient to create a warranty, so that the actual words do not have to be used. Statements of opinion or value are not considered part of the warranty. Values can go up and down. Values change in circumstances. So sellers are not deemed to be given any guarantee as to value. The only thing that they are giving guarantees are to facts. So the other thing is opinions. This is the best ice cream ever made on the planet. This is beloved by most of the people who have tried it. Anything that's an opinion is not part of the warranty. So large parts of the advertising, what in the old days we called puffery, these are the best shoes ever made, you'll feel wonderful wearing these, everybody will look at you and think you're great with this kind of makeup. These types of things are not considered part of the warranties. Buyers must show a reasonable reliance on some factual statement to claim it's part of the warranty, and the statement must be specific, reasonable, and it must be capable of being proven true or false for the buyer to use it as a claim of a breach of an express warranty. Now, there are two large implied warranties placed on goods by the UCC. And as we said above, an implied warranty is a warranty that is created by statute, and it is there whether the parties think about it, don't think about it. It can be excluded in certain situations, but by and large they cover all transactions for sale and leasing of goods. The first one is the implied warranty of merchantability, and what that is, it is a statement saying that these goods are reasonably fit for the purpose for which they are intended to be used. So a manufacturer of goods is telling a merchant that he is selling the goods to that these goods are reasonably fit, and this applies to the labels and the packaging as well as the item itself. The manufacturer or merchant doesn't guarantee that the product is free from all defects, but they are stating that it's reasonably able to be used and reasonably certain not to cause injury or damage. An implied warranty of fitness for a particular purpose is more specific. Here, the merchant is guaranteeing that the product will fulfill whatever use was intended by the buyer or the lessee. Goods can be merchantable and fit for one purpose but not for another. A pair of dress shoes may be merchantable, well-designed, sized correctly, durable, water-resistant. However, the shoes would not be useful for playing basketball or for running a marathon. The seller does not need to have knowledge of a buyer's particular intended use, but just have reason to know how the product will generally be used in public by individuals. Warranties implied from prior dealings or trade usage. So again, as we've seen throughout the UCC, that warranties can be created by the prior actions of the parties. Now, in addition to warranties created under the UCC, there are other warranties created by state and federal statutes. Under state law, there are things called lemon laws that apply to the purchase of vehicles, and they allow consumers who buy a lemon, a car that does not run correctly, with a remedy to basically give that car back and either get another car or get their money back. Most of these laws give the seller of the vehicle a number of attempts to correct the defect, and it's only after the attempted corrections fail that the buyer has the right to send the car back and seek a repayment or to seek another vehicle. Many of these laws require the parties to submit to arbitration, which means it's impossible or difficult to sue in court over this type of thing. That if you ultimately have a dispute with the dealer or the manufacturer of an automobile, you're going to go before an arbiter and you're going to have your case heard by a non-judge in a non-judicial setting. The Magnuson-Moss Warranty Act, a federal statute enacted by Congress, says that no merchant is required to give an express warranty, but if the cost of goods are over $25 and the seller does give a warranty, it must be clearly labeled as to whether it's a full or a limited warranty. A full warranty guarantees repair or replacement of the item. A limited warranty has limited promises from the seller. This act only applies to consumer transactions, and it requires that the warranties be fully disclosed in clear and everyday language in the packaging, in the brochures, so that the consumers understand exactly what the warranties are. Now, there is such a thing as overlapping warranties. A product can be subject to the UCC warranties and also come within the Lemon Law or within the Magnuson-Moss Warranty Act. When the warranties are consistent, the UCC says that all of them apply. If the warranties conflict, express warranties take priority over implied warranties. It is possible, in some circumstances, to disclaim or warranties or to limit liabilities. Right? Any express warranties can be disclaimed by stating this is not a warranty. However, this must be clearly stated and made visible to a consumer in a consumer transaction. Implied warranties, these can be disclaimed if the sale is advertised and stated to be as is or with all faults. This must be made clear to the buyer. Normally, in order to have this take place, I tell my clients it must be in writing, and the writing needs to be in big bold print as is with all faults. To disclaim the implied warranty of merchantability, there must be specific written notice using the name of the warranty saying that we are not giving it. To disclaim the warranty for fitness for a particular purpose, the seller has to put in writing that there are no warranties beyond any express warranty provided here. Defects which are reasonably ascertainable are not covered by the warranties if the buyer or lessor refused to do an inspection and did not notify of the nonconformity. So one of the things that buyers and lessors have to be aware of, that even though you do get warranties with products, you basically have a duty to uphold your own rights. And if you fail to inspect or fail to give timely notice, you may lose whatever protection you had under the warranties. Warranties can be disclaimed. However, it's very easy for a court to, particularly in a consumer transaction, say that a disclaimer of a warranty was unconscionable. If it was unconscionable, then the court will write the warranty back into the situation. As with the rest of the UCC, there is a statute of limitations on warranties. It is 4 years, and it runs from the date of the delivery of the good. So buyers must not only give reasonable notice of the breach of warranty, but they must file suit on it within 4 years, or they would lose their right to do so. Okay, guys, that ends chapter 23. That ends the course. I just want to say thank you all for putting up with this in these unusual circumstances. I feel very badly that we didn't get to do half the semester in the classroom, because that's part of what I like to do, but also I feel it's a very great part of the learning experience. This has been rather challenging and interesting time for me to get these courses up and running, and I know it's been a difficult time for you guys, so I thank you for sticking with it. Pay attention to Blackboard, get your quizzes and briefs into me, and stay safe and healthy.